Hello everyone. When you look through your contract, some of the things to pay attention to are the mediation and arbitration clauses, the venue and choice of law provisions, the termination clauses, and penalties for breach of contract. So what about these clauses? What do you have to look for in them? My name is Premkiranreddy, founding attorney of Reddy's Law Firm. In this episode, I will lean on my training and experience in both the medical and legal fields to answer these questions. Regarding mediation and arbitration, please see my other episodes on dispute resolution for more details. But in a nutshell, the contract may have arbitration and mediation clauses in lieu of filing suit in court. Remember that mediation can be more beneficial than filing suit. See if the contract you are signing has selected a venue and choice of law of another state than the one you reside and work in. You may see this if the employer's company is incorporated in or has its headquarters and principal place of business in that other state. You could negotiate this to be changed to the state that you reside and work in. Even if you aren't able to, check with your legal counsel to see if your state would refuse to enforce such venue and choice of law provisions if it is against public policy. Now let's talk about the termination clauses. Your contract can be terminated early, and this could be for cause or without cause. Let's talk about for cause termination. An example would be doing something illegal, some willful misconduct, or materially breaching a contract. A material breach of contract would be where one party did something significant enough to destroy the contract's value, like if something you did made you lose your license, and without your license you cannot work, which would be detrimental to the contract. Also, read the contract carefully to see if it has any other specific conditions or events, the occurrence or non-occurrence of which may trigger a breach of contract or contract termination. This may be attached to huge penalties or other serious consequences. We will go over the consequences in a subsequent episode. Now let's talk about the without cause termination. This allows either party to walk away from the contract at any time without giving a reason. For instance, there could be a provision for any party to leave as long as they give the other party a 90-day written notice. Let us talk about other termination issues you should be aware of. It is good to find out if you could terminate the contract in case of ownership change. If you are part of a group, find out what the buyout clause terms are. Again, you can negotiate all of these things before you sign the contract. So to recap, watch for alternate dispute resolution clauses in lieu of suing, look for venue and choice of law provisions, and the early termination triggers and consequences. Negotiate them to lower amounts before you sign the contract. Just remember to have the final negotiations written in the contract. We will go over the importance of having everything written in another episode. Please also be on the lookout for my various other topics, including other contracts, ethics, health law, medical malpractice, and dispute resolution. Thank you for watching. Hope to see you soon in the next episode. Bye-bye.